we submit that this evidence was emailed from claimant sides, and since claimants did not fulfill the requirement to prove some solid evidence to prove that it was obtained through illicit means, then failing to prove the requirement of standard of proof. So the burden of providing solid evidence still lies upon claimant, and we believe that they have not fulfilled this requirement.
So that means we cannot draw inferences on the from the uncertainty of the situation, in your opinion?
Yes. So, apart from its illegality, its relevancy and materiality shall also be taken into consideration. This Exhibit R3 is related to the realization of local content in our project. And throughout the whole process, respondent has always emphasizing the importance of the local content. Sorry, Mr. Presiding Arbitrator, I noticed that my time is running out. May I acquire the 1 minute to conclude my submission?
We're even going to give you 3 minutes because we have taken away time with questions, and by way of explanation, we will give, of course, the opposing side exactly the same number of minutes that the respondent had, and the same applies to the substantive issues that we subsequently will address.
Sure. So back to our submission, this Exhibit R3 is related to the local content realization, and it showcased that before the signing of the purchase and service agreement, claimant already internally aware that their negotiation with P2G has likely to fail. But later, they deliberately told us the opposite information, saying that they had a very good discussion with them. Together with claimant's later delay, we finally lost trust in claimant's ability to the realization of this project, therefore terminated this contract. So, this Exhibit R3 is still relevant and material to the current dispute. And coming to our last point, we submit that the legal advice privilege cannot be applied in our present case. We notice that this is a legal advice privilege, which is the head of the legal department is giving some advice to the CEO of claimant. But the regulation of legal advice privilege differ greatly from jurisdiction to jurisdiction. So when choosing the governing law, the close connection test is often applied. There are some factors to be considered when applying the close connection test. For example, the place where the relationship is established, the location of the client, and the jurisdiction where the lawyer practices law. Here in our case, the relationship between claimant and their head of legal department was established in Mediterranean, since claimant is a Mediterranean company. And the head of the legal department got her bar in Mediterranean. So we believe that based on the close connection test, the Mediterranean shall be the governing law of this legal advice privilege. But unfortunately, there was no relevant law of this legal advice privilege in Mediterranean. So we believe that the legal advice privilege cannot be applied in our present case. So in conclusion, we submit that Exhibit R3 can serve as evidence. In conclusion of our submission, we believe that the claim here has already did not fulfill the requirement of jurisdiction nor admissibility, so the tribunal should reject the claim, and the tribunal should exclude Exhibit C7 but not R3. If the tribunal does not have further question, this will...
Oh, the tribunal does. You earlier, when addressing issue number 1, interpreted the choice of law clause in the parties' contract as also extending to the matters of issue number 1. With issue number 2, or rather this particular document, you made a distinction, closest connection test. Wouldn't you say that that is contradictory? Or why is it appropriate in the particular context that you just addressed to have a separate approach in determining the applicable law? Why shouldn't Equatorianian law also apply to that particular matter?
Mr. Presiding Arbitrator, we here submit that for issue 1, we are choosing the governing law of the arbitration agreement, and we believe that Equatorianian law is the implicit choice by the two parties, so we do not have to consider the connection between those governing law. And for this legal advice privilege, the reason why we want to choose a specific governing law was because that the regulation differs greatly. For example, in some jurisdiction, they don't have the protection, and for some jurisdiction, they only have protection except for in-house lawyer. So we believe that it is necessary for choosing a governing law. But it is different from the governing law of the arbitration agreement, and we have to look into the content of this evidence, the information contained within. And from, for example, the location and the lawyer's bar, we can see that Mediterranean has this close connection. So we believe that Mediterranean will be the governing law of the legal advice privilege.
But isn't the advice given very closely connected to the merits of the dispute, to the agreement and how the parties should proceed with it? Wouldn't it therefore be kept caught by the choice of law clause in the contract?
Respectfully, no, Mr. Presiding Arbitrator. For example, it is stated in the ICC award, which is not published, but it's stated that when choosing the legal advice privilege governing law, it shall be regarded as differently from the governing law of the arbitration agreement or the main contract. The reason is that we have to maintain the parties' intention. And Exhibit R3 is an email that only lies in claimant side. So when they make this email, they will have no intention to apply a law other than Mediterranean. So we believe that from interpreting the parties' intention, Mediterranean law is the governing law of the legal advice privilege. So if this can answer your question, and well, this will end my submission. Thank you.
Any questions from my colleagues? Not at this point in time. Then we have spent 20 minutes on the procedural issues, and you, of course, will have the same amount of time. The claimant has the floor.
Thank you. Good afternoon, honorable members of the tribunal, distinguished guests. My name is Yichun Wang, and I'll be presenting on the procedural issues on behalf of claimant Green Hydro. In response to respondent submissions, claimant will make 3 submissions today. First, the tribunal should not reject the claim for lack of jurisdiction, admissibility, or as part of its discretion. Second, the tribunal should exclude the Exhibit R3, whereas the tribunal should not exclude Exhibit C7. Now, coming to my first submission, the tribunal should not reject the claim for lack of jurisdiction, admissibility, or as part of its discretion. First, to clarify, the applicable law for the first issue should be the Nubian law, which is a verbatim copy of the ancestral model law. The reason is that the parties agreed that the seat of the arbitration is the Nubia, and therefore the lex arbitri should be the Nubian law, which governs the arbitral proceedings. The validity of the arbitration agreement is not in question here, because the parties have by their own willingly entered into an arbitration agreement, whereas the only dispute is over a procedural arrangement to be governed by the lex arbitri, or the Curia law, that is the Nubian law. And as an initial matter, the claim should not be rejected for lack of jurisdiction, as the issue at hand is not a jurisdictional one, but an admissibility one. There has been a prevailing trend in recent years among courts in Hong Kong, Singapore, England, and Australia that recognize this distinction. For example, in 2023, the Hong Kong Court of Final Appeal decided in the C&D case that the non-fulfillment of pre-arbitration requirements raises an admissibility issue and not a jurisdictional one. To distinguish these two concepts, if it is an admissibility issue, the objection is towards the claim, and the tribunal has jurisdiction of the issue, whereas the tribunal's decision on the admissibility issue cannot be reviewed de novo by the court. However, if it is a jurisdictional issue, the objection is towards the tribunal, and the tribunal's decision that it has jurisdiction can be reviewed by the court. The court in the C&D case decided, as the parties are commercial entities which agreed that all disputes be finally settled by arbitration, there is no reason to treat this issue, the non-fulfillment of pre-arbitration requirement, differently from all other issues, and to instead leave it to the court.
So I'm sorry to interrupt you.
Yes.
Can you assist the tribunal to understand the case better by providing some of the factual background of this case, which you just referred to just now?
Yes. In the C&D case, the parties agreed that they shall attempt in good faith promptly to resolve dispute by negotiation, and later, all disputes shall be referred for settlement finally by arbitration. And the court decided, as the pre-arbitration requirement, the fulfillment of which is also a part of all disputes which shall be finally decided by arbitration. This issue should be left to the tribunal to decide, and therefore the tribunal has jurisdiction based on party autonomy, whereas the issue at hand is an admissibility one. And our case is similar in that Article 30 of the agreement similarly provides that all disputes shall be finally settled by arbitration. The issue of the fulfillment of mediation still falls within the scope of all disputes, and the tribunal has the jurisdiction to decide the issue based on party autonomy. And coming to the second part of my first submission, yes.
If we should follow you on that particular point and find that it is an admissibility issue and not a jurisdiction issue, what, in your view, would be the consequences for the present arbitration? Would we have to terminate it, or should we stay it until the mediation, should, of course, we find that the mediation first has to be conducted, until the mediation then has to be conducted, or do we have to terminate the arbitration entirely?
Mr. Presiding Arbitrator, we propose that tribunal does not have to terminate the proceedings. Instead, it could simply approve a stay of proceedings and set a time frame for the parties to comply with the mediation requirement. And we also have some reasons for our proposal. To explain, first, the tribunal should stay the proceedings as it would best suit the parties' intention and pursuits. As the England and Wales High Court have explained in a case concerning admissibility, it is business common sense that parties which refer to arbitrate would like to have their disputes decided in a one-stop shop arbitration. The present case is no exception. Now that this tribunal has already been granted jurisdiction and it has gone through all the exhibits and bundles, the needs of the parties could already be best fulfilled by this tribunal alone. As Gary Bone has pointed out, it would then be unduly formalistic to dismiss the tribunal, only to have the risk of having a new tribunal after mediation fails.
But doesn't that really presuppose that this tribunal would be able to find a suitable date for the next hearing, because we're all very busy arbitrators. So as a matter of fact, it may be more effective to just terminate the hearing and find 3 arbitrators that have less work to do than we have.
Propose that the tribunal could simply set a time frame for the parties and decide the date of the next hearing. And by doing so, it would be much more cost efficient, because if the tribunal should terminate the hearing, and in the case that the parties cannot reach an agreement in mediation, they would have to spend same or even more amount of time and costs that they have already spent up till now when they initiate a new arbitration. However, if the tribunal stays the proceeding, this tribunal could simply revisit the claims should mediation fail, and there would be no risk of waste of time and costs. And therefore, the tribunal should stay the proceedings instead of rejecting the claim and terminating itself.
Right. My question for you is, if the parties had displayed a clear intention to adopt the FAI model mediation clause and to adopt a certain procedure, is it actually intended by the parties that any party can just start the arbitration without taking the first step? Would that be the party's intention?
Yes, the party's intention may be that they want to mediate first, but the facts here is that they have already omitted this step, and we propose that the important question is how to cure this omission most efficiently without betraying their own willings. And therefore, we suppose that staying the proceedings could best cure this omission. And if the tribunal is satisfied with the first submission, we would like to turn to our second submission. The tribunal should order the exclusion of the exhibit R3. First, this tribunal has the discretion to decide the admissibility of evidence under Article 34(1) of the FAI arbitration rules, and it should exclude exhibit R3, which is an internal letter of legal advice within claimant, as it is subject to legal privilege. By its nature, the purpose of legal privilege is to encourage full and frank communication between attorneys and their clients to promote broader public interests. If a legal privileged document is omitted by the tribunal, it would greatly jeopardize the right of the party, as it could no longer receive frank and open legal service from its lawyer, which would lead to serious prejudice. Exhibit R3 should be excluded exactly for this reason. To be more specific, in our case, we suggest that Equatorianian law should apply on the issue of legal privilege, and Exhibit R3 is indeed subject to legal privilege rules under Equatorianian law. First, Equatorianian law should apply on the issue of legal privilege. Article 18 and ancestral model law, as well as Article 9(4)(e) of the IBA rules, all require equality and fairness in treating different parties, and a publication in the ICA Congress series further states that in the absence of agreement of two parties, applying the law of the country which gives the highest level of protection would ensure that the parties could have their expectations complied with and also avoid any unequal treatment between the parties.
If you say the highest level of protection, that of any country, or how do you select the countries in order to determine what the highest level is?
The highest level of the countries of the parties, because if the tribunal should choose a lower level of protection of the countries of the parties, then it would lead to unequal treatment.
But if we would follow your suggestion, then it would mean that the communication between your client and an advising lawyer, the degree of protection would differ depending on what counterparty they happen to be negotiating with. So the protection would be high if the counterparty is in Equatoriana. It would be lower if it's in any other country. Is that a logical conclusion?
Yes, the protection would be higher for attorneys and clients in Equatoriana, whereas it would be lower for communication in Mediterranean. But if the tribunal should adopt different rules for different countries between the parties, then it would lead to unequal treatment of the two parties. And in our case, we therefore suggest that Equatorianian law should apply, which is the most protective country as it follows the American approach regarding the legal advice privilege. And second, if I may refer the tribunal to page 55.
55, okay.
Yes, question 29 of page 55. An in-house counsel who at the same time is admitted to the bar is protected under the law of Equatoriana. As it is obvious that Mrs. Smith, as claimant's head of legal department and also admitted to the bar, was giving legal advice to claimant's main negotiator and CEO concerning assurances and misrepresentations, Exhibit R3 is subject to legal privilege under the rules of Equatoriana.
Just a question, because my knowledge of the file is not as good as it should be in this regard. Do we know that Ms. Smith is admitted to the bar in Mediterranean?
Yes. If I may refer the tribunal to page 32. Exhibit R3, page 32. The last line of this page provides that Mrs. Smith is admitted to the bar. Thank you.
And then your reading of procedural number 2 means as long as the party is admitted to, or the counsel is admitted to the bar, it can be any bar, not the Equatorianian bar, Mediterranean bar also suffices.
Yes. Thank you. And turning to the second part of our second submission, the tribunal should not exclude Exhibit C7 for the without prejudice concept. The purpose of without prejudice rules is to encourage the parties to attempt at amicably resolving the disputes in negotiations by assuring them that these attempts will not be used against them in later legal proceedings. The premise for the without prejudice concept to fulfill this purpose is that there are without prejudice rules, and a party could reasonably expect to be protected by them. However, while the without prejudice concept mainly stems from common law jurisdictions, they are not generally accepted in all countries, especially in civil law nations. In the present case, there are no cases or jurisprudence in the three countries, Equatoriana, Danubia, or Mediterranean, as to what the term without prejudice means. Therefore, respondent could not have had legitimate expectation that his offer shall be protected under this concept, as no without prejudice rule applies, and the purpose of without prejudice concept is defeated. Moreover, the offer itself does not fall within the scope of without prejudice offer at all. Without prejudice privilege applies only if the particular statement was made for a purpose of a genuine attempt to settle a dispute.
Under what particular legal order? I understand you just a minute ago said that there is no particular rule on without prejudice in either of the three countries, and now you're citing a rule. Where is that from?
Yes. First, for your first question, if I may direct the tribunal to page 55 of the problem. Question 30 of page 55. There are no cases or jurisprudence concerning without prejudice in all three countries. And our second step is to introduce the tribunal that even if the tribunal is not with us and would like to apply the concept of without prejudice, then the concept of without prejudice in common law nations is that the premise is the parties are making a genuine attempt to settle a dispute. And a genuine attempt could be making a compromise or being open to consider as well as to propose settlement terms. However, just in the opposite, such a genuine attempt cannot be seen in Exhibit C7. Respondent already knew that a price reduction was unacceptable for claimant in an earlier meeting with claimant on 12th of May 2024, and it only required again to seriously reduce the price in Exhibit C7. Neither has respondent left any room for further negotiation in the letter. Therefore, the without prejudice concept does not even apply in this scenario, regardless of the existence of relevant rules.
Counsel, how do you define genuine attempt to negotiate? Do you have any case law to refer to, help the tribunal to understand this better?
Yes.
Because apparently 15% reduction offer, commercially speaking, this is an attempt to negotiate, isn't it?
Commercially speaking, it could be attempt to negotiate, but we have a case named Best Buy Corporation versus Worldwide Sales Corporation decided by England and Wales Court of Appeal in 2011, in which it provided that the meaning of an offer alleged to be without prejudice should be answered by reference to what a reasonable person in the position of the recipient of the letter, with its knowledge of all the relevant circumstances, would have understood the writer have intended. However, in our case, in claimant's position, claimant already reduced the very favorable purchase price in the beginning, under which it would have made no profit, by another 5%. And as claimant was already making a deficit under the contract, and claimant made it very clear to the respondent that a further price reduction would be not acceptable, respondent only offered another price reduction which should not be deemed a genuine attempt.
Counsel, a follow-up question is whether a commercial offer to negotiate is acceptable or not, whether it commercially makes sense or not to one of the parties, is legally speaking different from whether you have commenced the mediation procedure or not. Is it?
Sorry, may I further clarify
I mean,
the question?
Commercially speaking, from your perspective, being the claimant, a further 15% reduction does not make commercial sense to you. It's completely unacceptable to you.
Yes.
So this is something very different, legally speaking, from whether you attempt to, or you have commenced the mediation or not, which is under the role of the mediation rule of FAI, this is a requirement for starting of or commencing of a mediation, which is provided in the agreement. So how do you justify that?
We understand that we have not commenced mediation because we deemed a further negotiation or mediation pretty much not likely to succeed. But we also admit that if the opposing counsel would like to mediate now, we would agree to mediation only under the circumstance that this tribunal stays the proceeding.
Please proceed.
Thank you. And members of the tribunal, the factual and legal circumstances surrounding the present case are clear. First, the tribunal should not reject the claim either for lack of jurisdiction, admissibility, or as part of its discretion. Second, the tribunal should exclude the exhibit R3, and it should not exclude exhibit C7. If I may not further assist the tribunal, this concludes claimant's submissions. Thank you.
Thank you very much. Any question to either side at this point on the procedural issues? Then we will continue and move on to the substantive matters of the case, and it is my understanding that the claimant will commence on it.
Mr. Presiding Arbitrator, I believe that there is still a rebuttal procedure before moving to the substantive issue.
I'm sorry, I overlooked that. Of course, you have rebuttal.
Thank you. For rebuttal, we have one point. We noticed that claimant just now mentioned they want to apply the most favored nation rules when choosing the governing law of the legal advice privilege. However, when choosing between Equatorial and Mediterranean, claimant believe that it will be better to choose Equatorial as it will provide a better protection of this evidence. But just as Mr. Presiding Arbitrator just mentioned, this will make no sense because the governing law will be different if the parties are different. So in this regard, we want to clarify that the most favored nation rules will be only a supplementary rules to the close connection test. That is to say, if there are some drawbacks when applying the close connection, we can use the most favored nation rule. But here, there is no such circumstances because the two parties are under the same legal system, which is Mediterranean law. So there will be no unfairness or inequality. So we believe that the governing law of the legal advice privilege shall be the law of Mediterranean. This concludes my rebuttal. Thank you.
Any rebuttal?
Yes. In response to their rebuttal, claimant submits that the premise for the current issue is that there is no agreement of the two parties on the applicable law, and as there is no agreement, this tribunal should decide one single certain rule to apply that provides the greatest protection for the two parties, as this could best ensure the expectations of all parties. If the tribunal applies the Mediterranean law, which is the least protective of the three countries, then the parties from Mediterranean and from Equatoriana could not expect a protection as they could have been protected. That is, the party from Equatoriana should have been protected, whereas it could not be protected. Therefore, the tribunal should choose the most protective law for both parties. Thank you.
Thank you very much. And with that, we turn to the substantive matters.
Thank you, honorable members of the tribunal. I'm Hongfan Ling, and in this part of the pleading, the claimant submits that the CISG is applicable to the purchase and service agreement, and then the parties have not validly excluded its application. Now, on issue 3, the claimant submits that the CISG is applicable to the agreement because each of the two legal requirements set forth in Article 1 of the CISG has been satisfied. Two submissions accordingly. First, this agreement is primarily a contract of sale of goods. Second, the parties' places of business are in different states. Above all, the claimant would like to specify the goods under the agreement. May I direct the tribunal to page 17 of the case file? Page 17. Is the tribunal with me? In the middle of the page, there is a calculation table detailing the investment made in the delivery of the plant. As confirmed by the Tribunal in Procedure Order 2, page 54, paragraphs 16 and 17, the highlighted items under the electrolyzer and EPC works section all refer to goods that are tangible and movable at the time of the delivery. So then, our first submission is that the agreement is primarily a sales contract, as the delivery of goods constitutes the preponderant part of the seller's obligations. Article 3, paragraph 2 of the Convention also applies to mixed contracts, including turnkey contracts, as long as the supply of goods constitutes the preponderant part of the seller's obligation. Then, CISG Advisory Council Opinion Number 4, Opinion 9, further provides that the term preponderant should be interpreted using two criteria: the economic value criterion and the essential criterion. The economic value criterion should prevail, and the essential criterion should only be used when a comparison of economic value is impossible. A line of CISG database cases have illustrated the adoption of the economic criterion, and among them, the 2009 spinning plant case is the most similar to ours. It deals with a contract for the delivering of a spinning plant, and the court noted that the CISG applies if the economic value of goods exceeds 50% of the overall price. Specifically, in that case, although the contract itself did not specify the cost allocation for goods and services, an earlier evaluation report confirmed that the economic value of goods constitutes the preponderant part. Based on this, the court ruled that the contract was subject to the CISG. And similarly, in the present case, while Article 7 of the agreement does not specify the cost allocation and simply gives a lump sum price, the table on page 17 clearly shows the economic value of each obligation. Members of the tribunal, this table was made known to the respondent during the negotiation and so has served as a calculation basis for the overall price in the agreement. And here, the highlighted parts, the value is 100 plus 40 plus 50 equals 190 million euros, representing 63.3% of the overall price. Hence, the claimant's obligations preponderantly involved in the supply of goods. In addition, the parties' intentions also align with the outcome of the economic test. CISG Advisory Council Opinion Number 4, Opinion 10, requires an overall assessment based on the parties' will to further supplement the outcome of the economic test, and relevant factors to be considered by courts and tribunals include the name of the contract and the weight given by the parties to different obligations under the contract.
Just to clarify, you have cited a case to us and the CISG Advisory Council. Why should we follow either of these two sources that you rely upon for your argument?
Yes, Mr. President, because Article 7 of the CISG established that this tribunal is obliged to interpret the CISG in uniformity, and therefore, for example, the CISG Advisory Council is a summary of international CISG case law and thus can provide a strong reference value to our case. And also, as for the spinning plant case, it has a very similar scenario to our case and therefore can also provide a reference value to our case. And so, back to our argument, and may I direct the tribunal to page 10 of the case file? So the title of this agreement, Purchase and Service Agreement, emphasizes the purchase aspect in the first place. And also, paragraph 4 of the preamble states that the claimant is The claimant is a leading producer of electrolyzers with experience in the use of the patent-protected PEM electrolyzers. Please the tribunal note, during the bidding process, although the claimant's PEM electrolyzers are far more expensive than the traditional electrolyzers, the respondent still chose them after weighing their technological superiority and efficiency. And also, request for quotation, Article 9 on page 9. On page 9.
Before you move on to page
Yes.
9, the recitals on the beginning or the preamble of the contract that you have just referred to, the next recital says, whereas both Green Hydro PLC and Equatorian Renpower are committed to jointly building the plant and making it operational. Doesn't that sound more like it's a different thing from a mere exchange of goods? The parties were actually joining forces to bring about a new plan of a new setup that had not been done in that particular way before. Wouldn't that mean that this is not a simple contract of sale, but more of a cooperation agreement?
Mr. President, however, we submit that although it is the delivery of the plant, but the delivery of goods is a very preponderant part of this agreement, as can be shown from the economic value of each obligations, and also the parties' intentions and interests on the particular plant components. And therefore, please the tribunal turn to page 9 of the case file. And here, Article 9 also mentions the importance of the material used for the electrolyzer part in satisfying the local content requirement. And besides, yes?
I was thinking of the point you raised just now. Did you characterize this project as a turnkey project, right?
Yes.
Okay. So are you aware of any case law that ruled otherwise, that is, turnkey project being not subject to, or where CIG wouldn't apply? Are you aware of any case law? Can you specify and advise the tribunal on some of the specifics of that case law?
Yes, Mr. Arbitrator, there are indeed some case law, for example, in the window production plant case, and the tribunal and the court ruled that it is a turnkey contract, and therefore the CISG does not apply. But
how do you distinguish that case law from the one at hand?
Yes, Mr. Arbitrator, because in that case, there is no clear reference to the economic value, and so the tribunal directly jumped to the overall assessment based on the agreement. However, in our case, there is a clear economic value reference as in page 17, and therefore can provide a clear guidance to the tribunal. And moreover, pursuant to the CISG Advisory Council Opinion number 4, paragraph 3.5, it is impossible to say that turnkey contracts are always or never governed by the CISG. A case-by-case analysis is needed to see whether the test of Article 3, paragraph 2 is satisfied. And as we just mentioned, the economic value test shall prevail.
Counsel, what bothers me is that you are relying essentially on a calculation that was exchanged by the parties prior to the conclusion of the contract. I believe we know that it was made available by a client to the opposing side.
Yes, however, Mr. Arbitrator, Mr. President, this table was made known to each party during the negotiation, and according to Article 8 of the CISG, any negotiation prior to the conclusion of the contract can also be taken into consideration when interpreting the party's intention.
But how do you reconcile that with our particular contract on page 13, Article 31, which contains an entire agreement clause stating that this document contains the entire agreement between the parties and is based on a model on purchase agreement? So wouldn't that be a contractual specification that does not allow us to take into account the negotiations unless they have found their way into the parties' agreement?
Mr. President, we're not suggesting that we should take that table into the agreement. However, we're suggesting that it can be used to interpret the terms, for example, the Article 7 of the agreement, because in Article 7, it only gives the lump sum price. However, that table provides a clear guidance how the costs are allocated for this total remuneration.
But you do agree that from the wording of the contract proper, we do know nothing about the allocation of the overall price to the respective task that your client would have to undertake, that we only learn from the table.
Yes, Mr. President, from the agreement we do not know. However, we need to take that table into consideration when we're interpreting the parties' intentions. And I will quickly turn to our second submission, namely the parties' places of business are in different states. Yes?
Before you go on, you lean very heavily on the economic value test
Yes.
to make good your argument. But is it your position that that test is to put before the parties' intention of the nature of the agreement and what the contracting party is to deliver, and that is to be subsumed by a test applied on the basis of economic value?
Ms. Arbitrator, we do submit that in the overall assessment test, the economic test should be used as a starting point to assess the party's intention. And if the party's intention is not aligned with the economic test, the result of the economic test may be override. However, in our case, it is also very clear that the party's intention and interest may lie on the supply of these plant components, because in the preamble it describes the claimant as a supplier of the of the PEM electrolyzers. And also, may I direct the tribunal to page 16. Page 16, paragraph 8. Paragraph 8, lines 2 to 6. It noted that the claimant won the bid also because it can provide a transformer readily available for the plant, which will significantly shorten the time frame of the total project. So therefore, it is obvious that the parties' interests and intentions rely on those critical plant components rather than other affiliated services.
Right. What is your best authority for your proposition, which you gave earlier?
Ms. Arbitrator, we do submit that in the CSG Advisory Council, it says that the economic value test shall prevail. And just in the situation when a comparison of economic value is impossible, then the essential test should be applied. And since I notice my time is running out, can I ask for some minutes extension?
Yes, you get 3 minutes.
Okay, thank you. So we will now move on to issue 4 and submit that the parties have not validly excluded the CISG. 2 submissions in particular. First, the plain wording of Article 29 of the agreement does not amount to an exclusion. Second, there is also no mutual intention to exclude. Article 6 of the Convention indeed allows the party to exclude the CISG, but pursuant to Advisory Council Opinions number 16, such intention shall be clearly manifested. Now, may I direct the tribunal to page 12 of the case file. Page 12, Article 29. For one thing, the choice of the law of Equatoriana does not amount to an exclusion. We did our research in the CISG database and discovered a line of case law in the recent 15 years showing that an intention to exclude should not be inferred from a choice of the law of a contracting state. From the typical cybernetics versus CD system case 2011, where the French Supreme Court held that the party's choice of the laws of France did not amount to an exclusion, to the very recent 2023 a stolen wheel loader case where the Swiss court ruled that reference to the law of Switzerland did not amount to an exclusion.
Did any of these cases concern a situation like ours where the successful bidder seller was selected by way of a reverse auction?
No, none of the case is considered. However, we do submit that the reverse auction is also not the type of auction prescribed in Article 2B.
I understand you haven't mentioned that point, and I was not trying to make you argue it now. What my point is different. Article 6, the exclusion clause in the CSG, or the provision on the exclusion, is commonly interpreted as meaning that we have to look to the particular circumstances of the case, what the parties intended. And isn't one of the factors we shouldn't take into account that in our particular scenario, the respondent chose two bidders from a range of offers that had been made for the particular goods and services that were to be provided, and that offers were submitted by both domestic bidders and international bidders, like your client. If we would read the choice of equatorial law in Article 29 of the contract as you have suggested, would that not mean that domestic bidders and international ones would be treated differently? Because if somebody is from Equatoriana and bids for the particular work, it will be Equatorian domestic contract law that applies. International bidders, if they reside in a CSG contracting states, would be subject to the CSG. Doesn't that mean that we have to read the particular clause differently in our scenario? Because if we would follow your argument, then that would lead to an equal treatment of domestic and international bidders. And that is something that we do generally not have in the law of public tenders. I know that was a complicated question, but maybe you can assist me with that.
Yes, Mr. President. However, we submit that interpreted in accordance with CSG Article 8, also no agreement has been reached between parties to exclude the CSG. The respondent may use the press release, which stated that the amendment was made to strengthen the role of Equatorian law, to say that they intend to use Equatorian law. However, it is at most the respondent's unilateral intention. And there is a key difference between the respondent's own aim to simply strengthen the role of Equatorian law and the parties' mutual and unequivocal intention to exclude the CSG. Because according to numerous authoritative resources, such intention must be clearly manifested in the agreement. Therefore, the CSG has not been validly excluded. And since my time is running out, if the Claimants Council cannot further assist the tribunal, that concludes my submission.
Thank you very much. We have spent 18 minutes and 42 seconds on this issue, and of course you will have the same amount of time. You have the floor.
Thank you, Mr. Presiding Arbitrator. Members of the tribunal and opposing counsels, good afternoon. My name is Hu Xiaohan, and today I will present merit part of this case on behalf of respondent Equatoriana Rainpower Limited. Respondent would like to draw a different picture of the case. In this case, claimant is responsible for the planning, engineering, and construction of a large-scale plant. However, claimant delivered the planning late and failed at the first milestone. Moreover, according to the Civil Code of Equatoriana, respondent can terminate contract for convenience. However, claimant tries to invoke the CSG to deny respondent's right to terminate for convenience. As a result, the parties now have disputes over the applicable law. Based on these facts, respondent would like to make two submissions today. First, the CSG is not applicable to the agreement. Second, the parties have validly excluded CSG's application. Turning to the first submission, respondent agrees with claimant's view that the purchase and service agreement is an international contract. However, respondent disagrees with claimant in the other point that the major part of the purchase and service agreement is actually service rather than goods. According to Article 3, Paragraph 2 of the CSG, if service takes up a major part in a contract, the contract falls out of sphere of the CSG. Claimant submitted that the economic criterion should be used. However, according to CSG Advisory Council Opinion Number 4, the calculation should be concluded at the conclusion of the contract instead of predetermined on.
However, in our case, the table submitted by claimant was a predetermined table because the table was shown by claimant to the respondent during the negotiation process. So respondent submits that the economic criterion cannot be used appropriately in our case. And just as claimant submitted.
Just to make sure I understand, your point is that the table was shown to your client before the contract conclusion and that therefore we cannot take into account? Or do I misunderstand?
Yes, Mr. Presiding Arbitrator, that's my point.
If it would have been shown at the moment of contract formation, we could take into account?
Mr. Presiding Arbitrator, respondent submits that the table was an internal calculation from claimant, and it showed the investment of the claimant instead of the final prices. So respondent submits that the table was a predetermined one, and in order to use the economic criterion properly, the table should, or the calculation should be considered at the conclusion of the contract.
So is it your submission that the figures in the table do not represent what may have been the true figures at the point of delivery?
Madam Arbitrator, there is possibility that the figures may not be the final or true figures, and moreover, respondent submits that the economic test cannot be used properly because it won't be until 2026 when respondent decides to exercise one or two or even none of the options. And if respondent choose to exercise none of the options, then the services and goods supplied by claimant in the options should not be calculated or considered by our parties. So respondent submits that the economic test cannot be used properly.
Maybe you could assist me with regard to the relevant point in time that this tribunal should look to in determining whether Article 3, Paragraph 2 applies or not, or what the result of its application is. Did I understand you correctly that you would say we would have to wait until your client exercises or does not exercise the options in the contract, and therefore wait until a moment in time after contract formation? Did I get that right?
Yes, Mr. Presiding Arbitrator, that's the point. So respondent submits that the economic test cannot be used properly here, and instead, it is the essential test that should be used. Thank you, Mr. Presiding Arbitrator. Just as claimant mentioned, the economic test should only be taken as the starting point of the evaluation, and the economic test result can be revised by the essential test. Respondent submits that the essential test should be used to determine the major part of the contract. Supreme courts in Swiss and German agree that the result from the essential test is more convincing. Under the essential test, the party's purpose should be considered. In our case, the purpose is to build up a large-scale factory that can produce green hydrogen.
I'll have to get back. German and Swiss Supreme Courts agree. Could you specify the cases in which that was said?
Mr. Presiding Arbitrator, the case was decided by the German Supreme Court, and the subject was the potato chips plant. And in that case, also a large-scale plant, where this the potato chips plant was to be delivered. And in that case, the German Supreme Court decided that the major part of the contract was service because it concerns a large-scale factory where it is also a turnkey plant. So the services takes up a major part. And this is also supported by Professor Schwenzer. She stated in her commentary that in the delivery of a large-scale factory, service is more important. And also, in the RTAG versus WT case, the court further reasoned that to put a plant into operation, service plays an important role, and the goods are rather simply material than the purpose of a sale.
Then your conclusion would be that turnkey contracts can never be governed by the CSG?
No, Mr. Presiding Arbitrator. Respondent submits that some turnkey contract may not be governed by the CSG. However, according to Professor Schwenzer, she stated specifically in her commentary that most turnkey contracts are not governed by the CSG because in such contract, engineering, procurement, and construction takes up a larger part. Now turning back to my submission, in this case, service is more important to fulfill the purpose of the purchase and service agreement. Planning as one of the services is especially important because it provides the detailed guidance for the construction work. And plus, the parties have put much emphasis on the sticking to the timeline, and in order to deliver the plan in time, planning is of much importance. May I refer the tribunal to page 3 of the case file.
Yes.
Page 3, which is in request for arbitration. Paragraph 7. Paragraph 7, the last third line from the bottom. For the other permits, which usually do not create any problems, the detailed planning was necessary. So this shows that the planning was indeed important. And may I refer the tribunal to page 11 of the case file. Page 11, Exhibit C2. Article 3, Terms of Delivery or Contractual Milestones. According to the cylinder case, if service is more detailedly stipulated, then it takes up a major part and it is more important. And in Article 3, all the stipulations are about services. For example, permission planning, final plans, and building activities. So respondent submits that the major part of the contract is service rather than goods.
Counsel, what bothers me is that particular clause you cite starts with the wording to ensure the timely handover. The contractor agrees to the following milestones. So it seems that these are preliminary steps that eventually would lead in the plant being ready and to be handed over to your client. If we would follow your argument, then any preliminary steps that you need to design any product would be service, right? You need to, this iPad, I'm sure a lot of planning got to that, but when I bought it, I concluded a sales contract. Now I'm not so sure anymore. So is it your position that we can take into account any services that were used or made in order to produce a good? Or isn't Article 3, Paragraph 2 geared towards services that are supplied alongside goods?
Mr. Presiding Arbitrator, respondent fully understands your concern. Respondent submits that the service here is more important because firstly, it is a turnkey contract, and according to Professor Schwenzer, turnkey contracts are usually excluded by the CISG because service takes up a major part. And secondly, in our case, respondent submits that the goods are not put much emphasis on because the PEM electrolyzer can be substituted by another electrolyzer called the alkaline electrolyzer. And this can be shown in page 54. Sorry, it should be page 55. Page 55, which is in PO2, paragraph 25. Paragraph 25, the fourth line. The second project, which involved a 50 MW plant based on an alkaline electrolyzation process. So this shows that in order to reach the purpose of the parties, which is to produce green hydrogen, it's not the goods that matters because the PEM electrolyzer provided by claimant can be substituted. So respondent submits that in this case, it is service that takes up the major part. And now stepping to our second submission. Respondent submits that the parties have validly excluded the application of the CISG. Respondent's argument will be twofold. First, respondent has a clear intent to exclude the CISG. And second, claimant also interpreted the choice of law clause as excluding the CISG. Turning to the first point, respondent has a clear intent to exclude the CISG. May I refer the tribunal to page 53 of the case file. Page 53, which is in PO2, paragraph 10. The second line. For all issues not regulated by the CISG, the law of Actuariana shall apply. So this indicates that the law of Equatoriana is separate from the CISG. And since the new choice of law clause, it removed the CISG and reserved the choice of law of Equatoriana, apparently the parties have excluded the CISG. Moreover, claimant also...
I'm going to ask you a question like asked the claimant earlier. That is a contractual or a communication that referred to the earlier model contract. Now, in Article, I believe 29 of the contract, we have an entire agreement clause that orders this tribunal and anybody else to only take into account what's actually in the contract, because the document contains the entire agreement. To which extent, if any, does that clause bar us from taking into account the earlier model clause in the earlier model contract and how it was modified?
Mr. Presiding Arbitrator, a respondent submits that Equatoriana is a dualistic state, and according to Crow's commentary, if a country is a dualistic state, the international treaty does not naturally become part of the law of the state. The international treaty needs to be transformed into part of the law of the state through legislation. And in our case, Equatoriana has not transformed CISG into part of the law of Equatoriana through legislation. So this fact also supports that the CISG and the Equatorianian law are separated, and since the new choice of law clause removed the CISG and reserved the choice of law clause of Equatoriana, so the parties have excluded the CISG. And stepping back to my submission, claimant also interpreted the choice of law clause as excluding the CISG. May I refer the tribunal to page 53 of the case file, also page 53. Paragraph 11. Paragraph 11, the sixth last line from the bottom. As Ms. Smith, the head of the legal department of the claimant, had interpreted the choice of law clause in the model contract to refer to the non-harmonized law of Equatoriana. According to a case decided in Italy, the court stated that the non-harmonized law does not include the CISG. If the parties refer only to the non-harmonized law, the CISG can be excluded. So this shows that claimant also regards the choice of law clause as excluding the CISG.
Although the clause did not refer to the non-harmonized law, did it? It just said plainly the law of Equatoriana, and the claimant has provided us with a significant number of case law that have all interpreted a unqualified choice of the law of a CSG contracting state as including the CSG. Does it matter that the clause does not say domestic law, non-harmonized, it just says the law of Equatoriana?
Mr. Presiding Arbitrator, respondent fully understands your concern. Respondent submits that Ms. Smith's interpretation of the choice of law clause can serve as the reference of the claimant, because according to Schwanz's commentary, the employee's knowledge can represent the knowledge of the employer, and moreover, respondent submits that Ms. Smith, as the head of the legal department of claimant, was involved during the negotiation process, because from paragraph 11, Mr. Law were meeting with a criminal investigation, and the following negotiations were conducted by Mr. Damon with the support of Ms. Smith. So respondent submits that Ms. Smith was involved in the negotiation process. So respondent submits that Ms. Smith's reference to or interpretation of the law can serve as claimant's intention. And now circling back.
Sorry, one last question. Ms. Smith was, as we know from that particular part, she was a labor lawyer who sort of moved to the head of the legal department. We do not know. Labor lawyers are very important colleagues, but maybe they're not the colleagues who regularly deal with international contracts. Couldn't that have been the reason why she misunderstood the meaning of the clause?
Mr. Presiding Arbitrator, respondent fully understands your concern. However, according to Schwanz's commentary, if a party's intention is very clear to exclude the CISG, then and the other party was aware of it, this can represent their common intention. And in our case, since respondent has clearly removed the choice of law clause of CISG, so this shows that respondent has a clear intent to exclude the CISG, and claimant was also aware of that change. So respondent submits that the parties have the common intention to exclude the CISG.
Is it your position that the tribunal should take into account the conduct of the parties during negotiation or representatives of the parties?
Yes, Madam Arbitrator. Respondent submits that in this case, the interpretation during the negotiation process can be taken into consideration. And in our case, since all of the conduct and interpretation shown by respondent was clear enough, respondent submits that the parties have validly excluded the application of the CISG.
What is the authority that you rely on in that proposition?
Madam Arbitrator, respondent submits that according to Schwanz's commentary, if the party's intention was clear and the other party was aware of it, and then this can show their common intention. And in our case, this intention was clear enough to exclude the CISG.
And is intention to be found by a tribunal on the basis of what was said or what was done before the contract was concluded, rather than on an objective interpretation of the terms?
Madam Arbitrator, respondent noticed the time is running out. May I respectfully ask for 30 seconds to answer the question? Thank you. Madam Arbitrator, respondent submits that according to Article 8 of the CISG, for the purposes of these convention statements made by and other conduct of a party are to be interpreted according to his intent, where the other party knew or could not have been unaware what that intent was. So, and in this case, claimants also were aware of respondent's intent to exclude the CISG. So the parties can exclude the CISG, and they have validly excluded.
So I have a question for you. Your position has been pretty clear. That is, there is clear intent from both parties to exclude CISG. If you look at the wording of the model contract, I would say it sounds a bit ambiguous, but regardless of that, do you think, or what is your position on this question? Can you imply exclusion of CISG? Is there any legal authority on this issue?
Mr. Arbitrator, may I understand your question as the legal authority of the exclusion of the CISG, or?
Yes, yeah. Can you exclude CISG by implying from the intention of the parties?
Yes, Mr. Arbitrator. According to Crow's commentary, the CISG can determine its own sphere of application automatically, and in order to determine the application of the CISG, the party's intent can be interpreted according to Article 8 of the CISG. Unless members of the tribunal have further questions, respondent hereby end our submission, and thank you.
Anything from the panel at this point?
Trying to interpret Article 8 as you have told the tribunal it ought to be interpreted. Does the last part of Article 8 of the CISG qualify the first two lines? And that is the words, where the other party knew or could not have been aware what that intent was.
Madam Arbitrator, respondent submits that in this case, respondent also made an official press release in relation to the amended model contract in 2022, and it explicitly mentioned that the changes were made to strengthen the role of Equatorial law. So respondent submits that claimant was aware of that change.
Do you have any indication that claimant actually read the press release? Or because it says knew or could not have been unaware, so...
Mr. Presiding Arbitrator, in this case, since Equatoriana is a government entity authority, and respondent submits that claimant should have known the intention of the respondent, and since the official press release was made publicly, so respondent submits that the change of the choice of law clause was known to claimant, and moreover, claimant has also used the former choice of law clause with two other business entities. And so respondent submits that claimant would have known the differences between the two model clause, and claimant knew in respondent's intention clearly.
I have one question that will go to both sides. Because it concerns an issue that has not yet been discussed, and it would be helpful to me if you would briefly address it, maybe commencing with the respondent who early on was about to address it when I asked a question that actually didn't go to that. There is a clause in the CISG that excludes contracts concluded sales by auction, as the wording is. And here we have a tender process that was conducted by the respondent before the claimant was eventually selected as the seller in the case. In your opinion, does that fact alone prevent, or does that clause in the CSG prevent this tribunal from applying the convention to the contract, quite independent of the choice of law clause in the parties' contract?
Mr. President, to address your concern, so we submit that reverse auction is irrelevant because according to the 2019 electronic electricity meters case, the buyer is a Swiss state-owned entity and conducted a public tender process calling for bids to deliver the electricity meters, and the successful bidder was a Slovene private company. And one dispute arose regarding whether CISG applied. The Swiss Federal Supreme Court concluded that a contract awarded to the highest bidder in the public procurement bid also falls within the sphere of the convention. So therefore, whether it is a reverse auction in our case also satisfies the application of the CISG. And to quickly rebut our opposing counsel's opinion, our opposing counsel's...
We're going to get to the rebuttal later on. Just want
okay.
to get to that point first. Thank you. And I'm eager to hear your response.
Mr. Presiding Arbitrator. According to the drafting history of the CISG, the core reason why auction is excluded by the CISG is that the auction's applicability of the CISG is predictable. Respondent submits that the application of the CISG is unpredictable here. According to the drafting history of the CISG, the predictability should be considered at the beginning of the auction instead of after the auction begins. And in our case, when the reverse auction starts, it's not known which seller will win the bid. So respondent submits that the CISG's application is not predictable and the reverse auction should be excluded.
Thank you very much. And now we come to the rebuttal.
One point to rebut. So our opposing counsel stressed that the turnkey contract is not governed by the CISG. However, according to the CISG Advisory Council Opinion number 4, it is impossible to say that turnkey contracts are always or never governed by the CISG, and instead, a case-by-case analysis is needed. And we have provided a case law, namely the spinning plant case, to prove that a large-scale plan can also fall within the scope of the application. And our opposing counsel also admits that the documents occurred in the negotiation can be used to interpret the party's intention, and therefore the table on page 17 can be included to show the economic value comparison between each obligation and therefore render the CISG applicable.
What is your rebuttal on the point about the figures being predetermined and not predetermined.
Ms. Arbitrator, we submit that indeed the economic value is predetermined. However, it is not to say that it cannot be taken into account. It should be used as a starting point to be supplemented by the party's intention. And as mentioned in our submission, the party's intention also preponderantly lie in the supply of goods. Thank you.
Sir, rebuttal on the 2 points?
Respondent agrees with claimants that it's hard to say whether all turnkey contract would be governed or excluded by the CISG. However, as Professor Schwenzer stated in her commentary, that if the contract concerns the engineering, procurement, and construction, and if it is a turnkey contract, then service mostly takes up a major part. And also in the RTAG versus WT case, the court stated that in a turnkey contract, usually the party's purpose is to build up the whole process and make the system function. And in order to reach that goal, service takes up a major part. And as for the table, respondent submits that the table is not only a predetermined one, and also it is not complete, because since the claimant did not deliver the planning for e-ammonia option, respondent submits that we cannot determine the prices of each obligation as for the divided service and good. So respondent submits, then here it is the essential test that should be used, and service takes up a major part. That ends my rebuttal. Thank you.
All right. One last chance to any question from the panel? Well, then I have one last question that goes to both parties. Have the parties been satisfied until now with the way these hearings have been conducted?
Yes.
Definitely.
Thank you very much. Then I conclude these oral hearings, and thank you for your arguments. We will now briefly give comments to the teams, and I would invite my fellow arbitrator, Ms. Tam, to start.
I would like to congratulate all 4 mooters on their extensive and their very thorough application and preparation for the arguments and the facts and the briefs. And I find that preparation is 80%. I can rate it even higher, 85% maybe, of excellence. And I think you all deserve the 85%. That's point number 1. And point number 2 is that I'm sure that in the course of your preparation, you will have prepared for difficult questions, and you know the weakest points or the most painful points to answer to in your respective briefs. And I would say that sometimes if the points are difficult to answer to, the way to deal with it is to make the slightest concession that may be possible to make, and then move on to other stronger arguments. And that is what we would do as advocates in courts, because concession is sometimes a point to show reasonableness and objectivity. And objectivity is what an advocate in arbitrations and in court hearings are gauged by to determine their quality. This is a strategy which is commended to all of you. I may have further points to supplement, but having been asked to speak first, that's all that come to mind for the time being. And I'm still overwhelmed by the excellent performance of all of you. Thank you.
Okay. Yeah, first of all, thank you. I echo the general comments from Winnie. I think you've done a superb job, all of you, all 4 of you. It's been wonderful to witness such a great event. I think you've done your best. I'm quite impressed by many things that I saw along the way during today's session. I think all of you have demonstrated that you know the material well. Everybody can memorize the stuff they are supposed to make oral submission. That is the way you should always do during a real commercial arbitration. I also see the teamwork going on, helping each other, assisting your teammate during the oral submission. If there's any hints and tips you want to help your teammate out, you've been everyone, I guess, during the presentation, you've been very focused, concentrating on the issue, and being able to interact with the tribunal very quickly. I think you know the case law. At least you appears to me that you know the case law very well, well prepared. A lot of efforts and energy going into this before you make this far to the final, which is a great achievement itself. In conclusion, I think I should congratulate you. You've done a wonderful job. Thank you.
Yes, I joined my fellow arbitrators. I was very impressed with the performances that I had the honor of watching today, in particular because within the course of this moot, it is very, very early. As you know, not even the claimant's memorandum has been handed in, so you still have to, maybe you picked up arguments for your written memorandum during these days. A few more specific comments of a general nature. I think within the oral hearings, the difficult questions are the ones that give you the best chance to shine. Sometimes the difficult questions are because the arbitrator hasn't quite understood the brief or the problem. And then you still were nice to us and to me and entertained questions that maybe may have a little bit off mark. That's also something you will encounter in Hong Kong and Vienna. And you will also see that arbitrators learn over time, particularly when none of them will be as familiar with the problem as you are. Maybe coaches will almost be as familiar, but other arbitrators like myself who do not coach, we learn. So in the later rounds, we know more than in the earlier ones. It is important that you try to answer the question of the arbitrator exactly, even if the question is something you say, I have no idea what he wants to, why he is asking that. And try the best you can not to give answers that you have prepared for a similar question, but not quite the one that you're being asked. Because increasingly you're going to have question where the arbitrator says, I have heard those arguments before, but what about this angle? That may be something new. And try to just respond off the cuff, even if you have not prepared it. That often is the most important one. Many of you did, or pick up points that either the arbitrator has raised when asking questions to the other side, and when it's your turn, you know that, all right, that has been raised, I know that he may be sympathetic to that view, and you can play with that. Of course, the arbitrator may turn around and then take the different position. And the same applies to points that have been made by the other side. If the other side seemingly has to rely on a particular document, then you can say, well, they have essentially conceded that we can use the table. And that shows to the tribunal that you can react to something that you have not prepared and modify your pleading accordingly. That's very good. Time management is essential. I'm a loose timekeeper. I only look at the quality of time distributions, but you will have arbitrators who are very strict. You say, 40 minutes is 40 minutes. You also can be very nice to alert the arbitrator when he has forgotten that rebuttal is still due. Right? You did that very well. That's a good point. Generally, you will find in Hong Kong and Vienna, the later points that you have prepared will always get less time than the earlier ones. Although it may not be deservedly so be prepared that you will have less then. My last point is as to authorities. The CSG Advisory Council has been relied upon by both sides. As I'm a member of the Council, I am generally positively disposed to such an approach, but you will see that there are very many arbitrators who have never heard of the CSG Advisory Council. So you should maybe be prepared to explain why we should listen to this group of private academics. And if I personally would have to choose, if I have a case, I'll take the case, because that usually will have a stronger precedential value. Also be very sure that you know which author you're citing, that that author has actually written what you claim he has written or she has written. Yeah, I'm not going to specify that any further. And congratulations to both of you. You did a great job. Thank you.
I'm now in a position to make a couple more points, having had the chance to think about them. First point, which may be of help to those in this room, because I can see that most of you are from teams, including the competitors today, making submissions in a language which may not be your first language. Now, I really appreciate the standard of mastery of the language that you are using in this moot, and I think it is to a very high standard. If you are not very used to using English as a working language, and in the mooting context, you would likely also be speaking to arbitrators who may not, the panel, who may not use English as their first language. So in this context, clarity of expression is essential. So you don't need to speak in beautiful tones, but you need to be very clear and very succinct. One way of dealing with it is not to add too much tonality to your sentence, but to grasp the most important words. It may be 2 words or 3 words or even 1 word, and give that word emphasis that is necessary, okay? And then forget about the rest or adding tones to the rest of the sentence, because it could confuse to someone who may not, who may have difficulties getting used to any particular accent. That's point number 1. Point number 2 is to deal with time pressure. It is very helpful for mooters to begin their submissions by a very succinct summary of their cases or the points that they are making. And that has been done by every one of you, and that's very much appreciated. Now, the panel members who will have read the brief will have been familiar with the points that are the salient arguments that are likely to be made. So the way to save time and to avoid undue time pressure is to ensure as little repetition as you can. And I couldn't agree more with the chairman on the point about understanding the questions properly and to make sure that you are answering the precise question. And if necessary, do not be afraid to ask what the person asking the question really meant in order to ensure that you've really gotten the point. And one can readily understand that sometimes it could be the voice of the person firing the question, or maybe in felicitous expression from the person firing the question, that you may not have understood the question properly. But it is better to ask rather than to just give an answer to deal with that particular moment. Thank you.
Thank you very much for your inspiring and enlightening comments. Well, let's applaud for the wonderfully presented final hearing. I think it's a common view of Moody's that each hearing session is I would say, a learning process, wisdom growing experience. Today's hearing, again, is a strong proof of that observation. We have heard questions that never been raised, even never been expected. We have heard arguments that never come up with. So all those are, I would say, eye-openers for your future mooting life and even for your future career. So please join me again to give our heartfelt thanks to the contesting teams for their wonderful performance, and especially to the tribunal members for their wonderful questions. So following, we have prepared tea break, some snacks and teas and the coffees for you to enjoy yourself outside at the foyer. And we will invite you back at 6:30 p.m. For those audience watching online, please stay tuned and join us at 6:30 p.m. for the awarding ceremony. We will unveil the winners. See you until then.
research and writing, oral presentation and advocacy, and to cultivate the mindset of a real advocate.
To the teams, please look at your coaches and teammates around you and say thank you.
喂。
behalf of our university teams, I would like to extend our warmest regards to all the members, participants, and supporters of the CETAC Moot Court competition who make this event possible.
祝冒重杯越办越好！祝冒重杯越办越好！
May the spirit of the competition and camaraderie thrive. May the CETAC continue to be the beacon for legal education.
对我们来说，这次的比赛是一个非常好的学习机会，也希望能够在这场比赛中和我的队友们发挥出最佳的实力，积累更多的学习经验。大家一起加油吧！
很荣幸能够参与这个比赛，与各高校学子切磋交流。
祝本届冒重杯顺利举办。
Here's to the CETAC Cup getting better every year.
Wish the CETAC all the best. 祝22届冒重杯圆满成功。
预祝第22届冒重杯比赛顺利进行，取得圆满成功。
预祝第22季冒重杯国际商事仲裁模拟仲裁庭辩论队
圆满成功，再创佳绩。凯歌而行，不以山海为远；
乘势而上，不以日月为限。
冒重，我们来啦！
祝22届冒重杯
举办顺利。预祝第22届冒重杯圆满成功。
I, as well as the rest of my team members, cannot wait to argue our positions in the CETAC Moot Cup, as well as here.
这边关就是要准备了。要喊吧。各位请尽快入座，我们的颁奖典礼马上开始。
Ladies and gentlemen, please be seated.